California Civil Procedure Handbook rules, selected statutes, and cases in comparative analysis. Chapter 10, Subpart B, California's Issue Preclusion Collateral Estoppel Doctrine. 1. Collateral Estoppel Doctrine generally. The California courts usually follow the restatement second of judgments when deciding questions of issue preclusion. See Walter v. Heiser, California's Confusing Collateral Estoppel Issue Preclusion Doctrine, San Diego Law Review, 1998. Court opinions often quote extensively from relevant sections of the restatement as well as from explanations contained in various sections' comments. Lucido v. Superior Court, 1990. In re Nathaniel, 1989, quoting Barker v. Hull, 1987. Sandoval v. Superior Court, 1983, relying on Section 29 and comments thereunder. Although California courts do generally rely on the restatement definitions in resolving collateral estoppel questions, the most common general statement of the California doctrine is as follows. The doctrine of collateral estoppel precludes relitigation of an issue previously adjudicated if 1. The issue necessarily decided in the previous suit is identical to the issue sought to be relitigated. 2. There was a final judgment on the merits of the previous suit. And 3. The party against whom the plea is asserted was a party or privy with a party to the previous suit, and that's from Producers Dairy Delivery Co. versus Century Insurance Co. 1986, and Bernhard versus Bank of America, 1942. Let me just read those elements. The issue necessarily decided on in the previous suit is identical to the issue sought to be relitigated, where there was a final judgment on the merits, and same parties, same places too, is what we discussed, at least in federal. In privity with a party to the previous suit, I already read that. Okay, so the California Supreme Court has restated these basic prerequisites and distinguished between the threshold requirements and the public policy considerations of collateral estoppel in Lucido v. Superior Court, 1990. Collateral estoppel precludes relitigation of issues argued and decided in prior proceedings. Traditionally, we have applied the doctrine only if several threshold requirements are fulfilled. First, the issue sought to be precluded from relitigation must be identical to that decided in the former proceeding. Second, this issue must have been actually litigated in the former proceeding. Third, it must have been necessarily decided in the former proceeding. Fourth, the decision in the former proceeding must be final and on the merits. Finally, the party against whom the preclusion is sought must be the same as or in privity with the party to the former proceeding. Even assuming all the threshold requirements are satisfied, however, our analysis is not at an end. We have repeatedly looked at the public policies underlying the doctrine before concluding that collateral estoppel should be applied in a particular setting. Accordingly, the public policies underlying collateral estoppel, preservation of the integrity of the judicial system, promotion of judicial economy, and protection of litigants from harassment and vexatious litigation strongly influence whether its application in a particular circumstance would be fair to the parties and constitute sound judicial policy. In Lucido, the Supreme Court refused to apply collateral estoppel even though the threshold requirements are satisfied, because to do so would be inconsistent with these public policies. Number 2, mutuality doctrine rejected. The California Supreme Court rejected the mutuality doctrine in a landmark case of Bernhardt v. Bank of America, 1942. The court noted that the criteria for determining who may assert collateral estoppel differ fundamentally from the criteria for determining against whom a plea of collateral estoppel may be asserted. Bernhardt supra, there is no compelling reason, this is quoted from that case, there is no compelling reason for requiring that a party asserting a plea of collateral estoppel must have been a party or in privity with a party to the earlier litigation. The court then articulated the now familiar inquiries for application of collateral estoppel. Was the issue decided in the prior adjudication identical with the one presented in the action in question? Was there a final judgment on the merits? Was the party against whom the plea is asserted a party or in privity with a party in the prior adjudication? The Bernhardt decision involved application of defensive non-mutual collateral estoppel, where the prior judgment is invoked defensively in a second action against a plaintiff bringing suit on an issue that the plaintiff litigated and lost as plaintiff against a different defendant in a prior action. The California courts also recognize the more controversial doctrine of offensive non-mutual collateral estoppel, where a plaintiff seeks to foreclose the defendant from litigating an issue the defendant has litigated unsuccessfully in a prior action with another party. See Iman v. Glassford of 1988 and White Motor Corps v. Teresinsky of 1989. So, two important words not to forget is defensive non-mutual and offensive non-mutual. I need to underline that with a pen. I'm not positive if they're both allowable in California, but it figures. Actually, we're in privity. Number 3, privity. So, generally, issue and claim preclusion can only be applied against parties who was also parties in the prior lawsuit. However, not only are actual parties bound by a prior judgment, but also non-parties who are in privity with the actual parties. Although traditional applications of privity were quite limited, the modern California doctrine is much broader. Privity now extends to any relationship between the party to be estopped and the unsuccessful party in the prior litigation, which is sufficiently close so as to justify application of the doctrine of res judicata or collateral estoppel. See Clemmer v. Hartford Insurance Co., 1978. This is a very flexible standard, which is limited, however, by the requirements of due process. California's modern doctrine of privity was explained in Dyson v. State Personnel Board, 1989. That's the appellate, I suppose. This is third here. The privity requirement has undergone an evolution in the law. Quote, traditionally it has been held to refer to interest in the subject matter of litigation acquired after rendition of the judgment through or under one of the parties, as by inheritance, succession, or purchase. Bernhardt v. Bank of America, 1942. The concept has also been extended to refer to a mutual or successive relationship to the same rights of property or to such an identification and interest of one person with another as to represent the same legal rights, and more recently to a relationship between the party to be estopped and the unsuccessful party in the prior litigation, which is sufficiently close so as to justify application of the doctrine of collateral estoppel. Clemmer v. Hartford Insurance, 1978. As one commentator has noted, the determination whether a party is in privity with another for purposes of collateral estoppel is a policy decision. The term, quote, the term privity in itself does not state a reason for either including or excluding a person from the binding effect of a prior judgment, but rather it represents a legal conclusion that the relationship between the one who is a party of the record and the non-party is sufficiently close to afford application of the principle of preclusion. The emphasis in the analysis is upon the policy of ending litigation where there has been a fair trial of one's interest, as it has been observed that the doctrine of res judicata is primarily one of public policy and only secondarily of private benefit to individual litigants. Vestal preclusion, res judicata variables, parties, 1964. However, the expanded notions of privity notwithstanding collateral estoppel may be applied only if the requirements of due process are satisfied. Clemmer v. Hartford Insurance. In the context of collateral estoppel, due process requires that the party to be estopped must have had an identity or community of interest with an adequate representation by the losing party in the first action, as well as that the circumstances must have been such that the parties to be estopped should reasonably have expected to be bound by the prior adjudication. Citations omitted. Thus, in deciding whether to apply collateral estoppel, the court must balance the rights of the party to be estopped against the need for applying collateral estoppel in a particular case in order to promote judicial economy by minimizing repetitive litigation, to prevent inconsistent judgments which undermine the integrity of the judicial system, or to protect against vexatious litigation. Citations omitted. Notes and questions regarding privity. 1. Is sufficiently close a workable test or simply a conclusion? How is sufficiently close defined? Do the due process requirements provide a clear definition of sufficiently close? 2. California courts have found privity to exist in a variety of relationships such as A. Successors in interest, B. Persons represented by a fiduciary, C. Persons who have a proprietary financial interest in the control of the conduct of a lawsuit, may be bound even though not a party, and D. Individual members of a homeowner association may be in privity with the association, and E. A governmental entity may be in privity with the individual claimants it represents. I'm not going to actually elaborate on A through D. Unnecessary. And that's going to be it for California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis.